Hello, my name is Ndukan Joku. I'm your lecturer for PUL 446, Law of Evidence 2. Today we are going to look at another topic in the Law of Evidence 2, and that topic is standard of proof. At the end of the lecture, you will appreciate the nature of standard of proof. You will also appreciate and understand standard of proof in criminal cases, and understand what it means when we say that standard of proof in criminal cases must be beyond reasonable doubt. You will also understand standard of proof in civil cases and understand what it means when we say that standard of proof in civil cases must be based on preponderance of evidence. You will appreciate and enjoy today's course. Thank you.
You will appreciate and enjoy today's course. Thank you.
You are welcome once again to today's lecture. We are looking at the concept of standard of proof. My name is Ndukan Joku. At the end of this lecture, you should be able to define the concept of standard of proof, explain standard of proof in criminal cases, and explain standard of proof in civil cases. What is the definition of standard of proof? In what ways is standard of proof different from burden of proof? Burden of proof is actually concerned with who has the burden of proving the facts before the court. But standard of proof is different. Standard of proof is concerned with the quantum of evidence, with the amount of evidence that will be required for the court to find in favor of the person on whom the legal burden lies. What is the amount of evidence required to prove a case? So we can say that standard of proof is meant the degree by which the weight of evidence adduced by the party on whom the legal burden lies should be heavier than that of the other party, so as to enable the court to find for him. That is what standard of proof is concerned with. If the legal burden of proof is somebody, what is the weight of evidence which that person must adduce before the court will find for him? Let us look at standard of proof in criminal cases. Standard of proof in criminal cases is said to be proved beyond reasonable doubt. That is the standard that is required of a criminal matter in court. And this is provided under section 135 subsection 1 of the Evidence Act 2011. It says that if the commission of a crime by a party to any proceeding is directly in issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. The understanding what is the meaning of beyond reasonable doubt is actually difficult. It's not usually easy to explain it, but it does not mean that it must be proved beyond a shadow of doubt. All he said that the evidence should be so strong as to leave no probability of accused person's innocence. No material doubt should exist as to whether the accused committed the offense or not. And where there is a material fact, where there's a material doubt as to whether the accused person committed the offense or not, the usual course open to the court is to hold that the prosecution has not made out its case against the accused person. Then the court will acquit the accused person. Now let's look at one of the cases where Lord Denning tried to explain what proof beyond reasonable doubt means. In the case of Miller versus Minister of Pensions, Lord Denning tried to explain the meaning of proof beyond reasonable doubt. He said that that degree is well settled. It did not reach certainty, but it must carry a high degree of probability. Proof beyond reasonable doubt does not mean proof beyond a shadow of doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect the cause of justice. If the evidence is so strong against a man as to leave only a remote possibility in his favor, which can be dismissed in a sentence, of course it is possible, but not in the least probable. The case is proved beyond reasonable doubt. But nothing short of that will suffice. Although we said that in criminal cases should be proved beyond reasonable doubt. But to prove a case beyond reasonable doubt does not require a particular number of witnesses. One witness is sufficient in order to prove a case beyond reasonable doubt, except in those circumstances in which the law requires corroboration. In that wise, the law will require that the evidence or the testimony being offered by the witness should be corroborated by another evidence. Except such circumstances, an evidence of one person may be sufficient to prove a case beyond reasonable doubt. In this class activity, you are asked to discuss standard of proof in criminal cases. Let us look at standard of proof in civil cases. The standard of proof in civil cases is based on balance or preponderance of evidence. So what do we mean that when we say that proof in a civil proceeding or civil cases are based on preponderance of evidence or balance of probabilities? What do we mean by that? It means that a party who brings a stronger evidence in terms of quality wins the case. It is not dependent on the number of witnesses called, but on the probative value of the evidence produced. That is simply what it means when we say that in civil cases that proof must be based on balance of probabilities or preponderance of evidence. And this is provided for under Section 134 of the Evidence Act 2011. It says the burden of proof shall be discharged on the balance of probabilities in all civil proceedings. Let us look at the case of Mogaji and Odofin, where the Supreme Court tried to explain what is the meaning of balance of probabilities. It says the judge should first of all put the totality of the testimony adduced by both parties on an imaginary scale. He would put the evidence adduced by the plaintiff on one side of the scale and that of the defendant on the other side and weigh them together. He will then see which is heavier, not by the number of witnesses called by each party, but by the quality or probative value of the testimony of those witnesses. In determining which is heavier, the judge will naturally have regard to whether the evidence is admissible, relevant, credible, conclusive, or more probable than that given by the other party. So that is the basis. There's an imaginary scale in the mind of the judge, and the judge weighs the evidence given by both parties. The evidence given by the plaintiff, he puts it on one side of the scale, the imaginary scale, and the evidence given by the defendant, he puts it on the other side of the imaginary scale and begins to weigh. Whichever weighs heavier then wins, no matter how slight. But we must bear in mind that when serious allegations are made in court, a party making such serious allegation must endeavor to bring high evidence of high probative value, will require a higher level of proof in order to win in his case. We may look at other cases like Amasa versus Kosode and the SPDC versus Olarewaju. But we must bear in mind that in matrimonial causes, the law requires that proof should be based on reasonably satisfied. There is an argument as to what is the meaning of reasonably satisfied, which the law requires in matrimonial cases, especially on allegations of adultery. Some people believe that reasonably satisfied means a proof that is higher than proof beyond proof but on balance of probabilities, but is lower than proof beyond reasonable doubt. And some people believe that that particular law has created another standard of proof. In the next slide, we will look at a class activity and we will be required to provide an answer to it. Discuss the standard of proof in civil cases. Today we have looked at standard of proof, what standard of proof means. We also examine standard of proof in criminal cases, which it is said to be beyond reasonable doubt, proof beyond reasonable doubt, and standard of proof in civil cases, which is based on balance of probabilities or preponderance of evidence. I hope you have enjoyed today's class. Thank you.